Okay, just give me a minute. I need to bring out the file. The presentation, please. The presentation.
Respectfully, my lord, One Bamala, my humble appearance is for the complainant. Good morning, my lord.
Good morning. I apologize for the hitches this morning.
May it please this honorable chairman, when we Ngohi, my appearance for the defense. Good morning, my lord.
Good morning. Yes.
My lord, the matter is coming up today for judge.
Yes.
But the defendant, his way from Maiduguri, they are just close to Damaturu. In view of this, my lord, we humbly apply for a very short stand down, either 30 minutes, my lord, to enable him come and attend the court, my lord.
We hold no objection, my lord.
This matter is stood down to 11 o'clock.
As God pleases, my lord. Thank you.
Yes, go ahead. Registry of court, are you still there? Is registry of court there? Can't seem to see them on the screen. Registry, can you unmute? Registry of court. Are they offline? I've seen their gadget, but I've not, no audio at all, no video as well. Court registry. Are they offline?
My lord, they are online. Maybe they are having a but they are here with us. I can see them.
Yes, I can see. Unfortunately, I'm using my phone, so I can't call to find out what is happening. I apologize to all council. The hitches we're experiencing this morning, I can't seem to understand what is happening. So if one of council can call the registry of court to find out what is happening.
Okay, my lord, go and meet them.
Okay, because I can see two gadgets from the court yet they are not visible. They are unmuted. Okay, I've seen a text message saying that they are having network challenges. Okay, I can see open court. But you're still muted. Your video is visible, but you are muted. Can you hear us, registry?
Yes, my lord. Yes, we are back, my lord.
Okay. You need to call the next case. This other case has been stood down.
As what is my lord? Charge number XS/B/C/4/ Nigeria and Idris Yusuf, Sani Idris, Abbas Abdul Rauf, and Muhammad. Yes, my lord. The first defendant is at the correctional center. When the third, fourth, and fifth defendant are asked.
It says the first defendant is at the correctional center.
Yes, my lord. Well, the third, fourth, and fifth defendant are asked.
While the third, fourth, and fifth.
Third, fourth, and fifth
are not before the court?
Yes, my lord. They are not before the court.
But then why is the correctional center not online? Mr. Ndahi.
Yes, my lord. Maybe
why
they
is the
are facing
correctional
network
center?
issues.
You're sure they're having network issues?
We just spoke. Yes.
Okay. Then it means Damaturu is having challenges. Okay. But then I can see council. Maybe those in
They are complaining of
okay.
Yes, we just spoke with them a lot. They are complaining that they have network issues.
Okay. Okay. Representation, please.
Respectfully, my lord.
Okay.
A humble appearance for the complainant.
May my lord be pleased? I am said I must appearing alongside we are holding brief for only announcing appearance for the defendants. My lord.
Yes. Go ahead.
My Lord, the matter today for the sentencing of the first defendant, who is at the correctional center, my Lord. While the third, the second, third, and fourth defendants, my Lord, are still on transit. I have been trying their number, but it's not reachable, my Lord. Honestly, my Lord, I hate telling such stories to the court that the event is not in court on time, my Lord. But I still have no
Your
option.
laptop, counsel, I didn't hear. You see, you have been trying the number. It has not been going through.
Their number is not going through. They are on transit,
Okay.
my Lord.
Okay. Yes.
Never, my Lord. If the correctional center are online, my Lord, we can proceed with the sentencing of the first defendant subject to the overriding convenience of the court.
Counsel, you said you have been trying the number. You have not completed that sentence, and the numbers not going through.
My Lord, their numbers are, they are still on transit, my Lord.
Yes.
So, my Lord, if the correctional center are online, we can proceed with the sentencing of the first defendant subject to the overriding convenience of the court.
The Fortiskum Correctional Center is not online, as you must have observed.
Yes, my Lord, they are not online. They are having network issue.
Counsel, you have heard that?
As the court pleases, my Lord, I have heard what the registry said. In view of this, my Lord, we have to give minutes to put their house in order so that they can be online.
In view of that,
my Lord, we have to give them some minutes, my Lord. The correctional center.
Counsel, do you want this matter to be stood down? It's the application I'm waiting for. You are going around the bush. You have not said anything to me. You said your clients are on transit. So what is it? What do you want? I just want your application so that I know how to move forward.
My Lord, what I said is that despite the absence of the second, we can proceed, my Lord, with the first defendant sentencing when the correctional center are online. May we give them some minutes, my Lord, to put their house in order, my Lord, so that they can be online, so that we can make progress.
Matter stood down to 11 a.m.
As the court pleases. My Lord, case number.
Court.
Okay.
Yes, okay.
Hold in this case.
Sorry, my Lord, case
Counsel, you were trying to say something?
Yes, my Lord. I said case number 3 And case number 4.
You are all frozen on the screen, meaning that you are the
Sorry, my lord, I
defense
didn't hear you.
counsel. Okay, for a few minutes, I think there's a network challenge. Registry of court.
Yes, my lord.
All the cases for today are the inmates, are the defendants at the Potiskum Correctional Center, or do we have some that are on bail?
Yes, my lord. We have some that are on bail.
Okay. Before the issue of connectivity is restored, you can call the next case. This matter is stood down to 11 a.m.
Charge number FSC/DM/ER/.
You wanted to make a submission? The prosecution counsel from NDLEA?
Yes, madam. I wanted to say this to this honorable, but we are bound to face network challenges, my lord, within the days, my lord. This is as a result of the security issues, my lord. So network is, we are going to have a network problem whether we like it or not. So we will just manage what we have at hand.
Okay, thank you for the information.
Well, in a solved case.
Charge number FSC/DM/CR/51/2023 between Federal Republic of Nigeria and Aisha Sabu.
Yes, my lord. Defendant is in court and she speaks Hausa.
Just give me a minute. I'm trying to bring out the file. Yes. Representation?
May it please, my lord. R. Muhammad is my name. Appearing for the defendant, my lord.
Any other representative or representation for?
No, my lord. The complainant that was not before the court.
Yes.
Yes, my lord. The matter was fixed today for continuation of defense, my lord. The Dwallet with DWT, we are closing our case for the defense, my lord.
Yes.
Yes, my lord. We are closing our case for the defense, my lord. And we are seeking for a date to enable us to file and adopt our final written address, my lord.
Registry, can you give us a date?
As the court pleases, 23rd April, my lord. April 23rd.
This case is called, the defendant is before the court. The prosecuting counsel is absent without any correspondence. The matter is hereby adjourned to the 23rd day of April 2026. Counsel are to file and exchange their final written address before the next adjourned date. The defendant is to continue to enjoy the bail granted her to the next adjourned date.
An ɗaga wannan zama sai ranar 23 ga watan Yuli. Za ki ci gaba ki je ki ci gaba da.
Thank you, my lord. We are much grateful.
You're welcome. Please call the next case.
Touch number FSC/DM/13/2025 between Federal Republic of Nigeria and Ibrahim Umar Lafia and one another.
Representation. Registry of Court, you have not informed me whether the defendant is before the court or not.
Yes, defendant is absent.
Representation.
Defendant is not in court.
Okay, thank you. Give me a date.
23rd day of April, my lord.
This case is called, neither the defendant nor the defense and prosecuting counsel are before the court. The matter is hereby adjourned to the 23rd day of April 2026. The defendant is to continue to enjoy the bail granted him to the next adjourned date.
That number, evidence and not like BM/3/39/2022 between Federal Republic of Nigeria and Garba Sarkin Fawa.
Yes, my lord. Defendant is on court and he speaks Hausa.
Representation.
Respectfully, my lord Usman Bamala, my humble appearance is for the complainant.
Defense counsel. Yes. Yes. Prosecuting counsel.
Yes, my lord, the defense counsel is with us.
May it please, my lord.
Who is the defense counsel?
My lord, he is Mohammed Abdullahi Doya. He's here with us, my lord.
May it please, my lord. May it please, my lord. M.A. Dawia is my name. May it please, my lord.
Yes, we can hear you. Continue. Yes, counsel, I'm waiting.
Maybe he's having a network challenge.
The prosecuting counsel, can you
Yes.
introduce the
Okay.
Oh, is he back?
Yes, my lord, he's back.
I'm waiting for the counsel to address the court.
My lord, the case of Garba Ispa was called, and I've not been hearing the proceedings. Leave the meeting and
I didn't hear your submission, counsel.
My Lord, the registrar called the case of by S Power of Nigeria, and from there I did not hear the proceedings of the court. That's why I leave the Zoom and rejoin. And I've experienced a network glitch, but I can now hear the proceedings, my Lord.
You have introduced yourself, so can you just go on since you can hear us? We are waiting for you, either the prosecutor or defense counsel.
My Lord, the matter is selected today for continuation of hearing. My Lord, to my own dismay, this is the last witness I intend to call in this matter. And unfortunately, my Lord, the witness will always give me the assurance of availing himself, my Lord, throughout the proceedings. Unfortunately, I will not see him. So, my Lord, this why he is not with us, I have no idea why. But I assume maybe it's as a result of the network. And I don't like this particular matter also, my Lord, to stay, even if it is a bit longer again. So, my Lord, in these circumstances, I apologize to the defendant as well as the counsel and the court at the same time. May I be asking for another date, my Lord? In the next adjourned date, my Lord, I should be foreclosed if I fail to produce the last witness. Thank you.
Any response?
Yes, my Lord, we have had the submission of the prosecuting counsel, my Lord. And we reluctantly concede to the application for adjournment.
Give us a date.
29th day of
my Lord,
February.
but we crave the indemnity. We don't need a definite decision so that we can close the case, even though witnesses were produced.
This case is called, the defendant is before the court. This honorable court, having listened to the application of the prosecuting counsel, This matter is hereby adjourned to the 23rd day of April 2026 for a definite hearing. Proceedings to be by virtual mode. The defendant is to continue to enjoy the bail granted him till the next adjourned date.
Thank you, my lord.
God, please. I must break.
Sorry, my lord. It's 29th, my lord, not 23rd.
Okay,
Sorry.
29th April.
Yes, my lord. Thank you, my lord.
Okay. Matter adjourned to the 29th day of April 2026.
Thank you, my lord. Ga wannan zama sai ranar 29 ga watan hudu. Ka ci gaba da zama. Wanda ya kamata ya zo ya ba da shaida bai sa zo ba. Lawyer mai gabatar da kara ya ce a baka hakuri, a ba wa kotu hakuri.
Yes.
Call the next case.
Tax number FSC/DM/CR/18/2023 between Federal Republic of Nigeria and Mohammed Musa Bello.
Defendant is
Respectfully, my lord Usman Bamala, my appearance is for the
Also,
complaint.
just give me a minute. I need to read out the file. Is that CR18?
CR18.
Yes.
Yes, CR18, 2020.
Representation, please. Is the defendant in court?
No, my lord. But his surety is here before the court, my lord.
I didn't hear that.
The defendant is not before the court, but his surety is here, my lord.
The defendant is not in court, but the surety is in court.
Yes, my lord. Yes, my lord.
Representation.
Yes. With the greatest respect and much honor, my lord Usman Bamala, my humble appearance is for the complainant.
Respectfully, my lord, M.A. that is my name. My appearance is for the defendant.
Yes.
Yes, my lord, we first apologize for the absence of the defendant, my lord, in court. This is due to the fact that my lord tried all my possible best to reach out to the defendant, but I couldn't, my lord, confirm. As such, my lord, I was able to reach out to his surety, who is before the court, my lord.
So, my lord, I humbly apply that the registry of the court will ask the surety as to the whereabouts of the defendant. Thank you.
Sorry, my lord, I didn't get the last submission of the counsel to the defendant. Please, can you come again?
Your submission to enable the prosecuting counsel, hear you?
Okay, my lord. I said I was unable to reach out to the defendant, my lord. I tried all my possible best to reach out to him on phone, but I couldn't. So as such, my lord, I was able to reach out to his surety, who is before the court. So, my lord, I humbly apply that the registry should ask the surety as to the whereabouts of the defendant, my lord. That's my submission. Thank you.
Did you hear his submission? The prosecuting counsel?
Yes, my lord, we have had the submission of the counsel to the defendant, but we have nothing to say now.
Okay. Register of court.
Yes, my lord. Surety to the defendant.
I didn't hear that.
The surety to the defendant before the court, my lord. Kotu tana so ta san mene dalilin da Musa Muhammad Bello baya so. He said his name.
You need to interpret, and then there's so much echo coming from the court. Maybe you have 2 different or 3 different gadgets. So can you interpret?
Yes, he said his name is Usman Mairabo. Yakubu Mairabo.
Did you say his name is Yakubu Mairabo?
Yes, my lord.
Yes.
Ina shi
Muhammad Musa Bello yarinsa ba lafiya ya kai shi Kano ya kusan kwana 3 yanzu.
He said the defendant is not feeling fine.
That the defendant is...
Yes, his son is ill. Defendant's son is ill. So he took him to Kano for medication.
Yes.
She can. Yes, my lord. That is why.
Yes, my lord.
Yeah.
Yes, counsel.
His network is seized, maybe. Yeah. His network is frozen, something like that.
Council, we're waiting for you, the defense council.
Yes, my lord. Sorry, my lord, I'm having network problem. My lord, we haven't heard from the surety to the defendant. My lord, we crave your indulgence to present this matter to another day to enable the defendant, my lord, appear and stand for his trial. My lord, we are very much sorry for any inconvenience this might have caused the court and the prosecution side, my lord. We will make sure in the next agenda the defendant is before the court. Thank you, my lord. Thank you.
Yes.
Any response from the prosecuting counsel?
My lord, while we are not objecting, my lord, we at the same time, my lord, urge the defendant, my lord, through the surety, my lord, to have him before this honorable court in the next adjourned date, as the matter has come to an end, so that we will all be safe, my lord, so that the matter will come to an end with logical conclusion, and I think playing this side of the game. And it will be heartless for someone to object when somebody is averting reasons of sickness, even though without proof. So, my lord, we are at this critical time, my lord, we are very mindful of every step. So, we are begging for the defendant to come back to this honorable court, my lord. Let the council inform him. Let him come back so that we can have the matter properly concluded, my lord. I have my reasons for this submission. Thank you.
Registry, interpret to the surety.
Lawyer mai gabatar da karatun bai da ja sosai, amma ka tabbatar cewa ran da za a sa na gaba ya yi kokari da kotu. Tunda shari'ar nashi ya kusan zuwa ƙarshe, yana yi wa ɗanci.
In Allah da an samu sauki ko gobe ma zai.
Give me a date.
29th April, my lord.
This matter is hereby adjourned to the 29th day of April 2026. The defendant who is on bail is to continue to enjoy the bail granted him to the next adjourned date.
We are grateful, my lord. Thank you so much.
Holiness case.
Tax number FSC/DM/CR/45/2023 between Federal Republic of Nigeria and Damaturu.
That, my lord, defendant is in court and he speaks Hausa.
Yes, representation.
Respectfully, my lord, one Bamala, my humble appearance is for the complainant.
Counsel for the defense.
With
No
the
counsel.
greatest respect and humility to my noble lord, M.A. Dawya, is my name. I announce my appearance for the defendant, my lord.
Yes.
Yes.
My lord, this matter is related for defense.
Counsel, we are wasting too much time. Yes.
Most of that, but they are not ready, my lord. Reason being that the substantive council handling this matter in the person of Dr. Akiltimehi, my lord, who appeared in the last sitting, my lord, had gone away with the file at home, had gone away with the case file at home, and she is now in Lagos, my lord. In view of this, my lord, we respectfully crave your lordship's indulgence to graciously adjourn the hearing of the defense. We'll be suggesting, subject to your lordship's convenience, the 29th day of April, my lord, and that of the prosecuting counsel, my lord.
Lord, we fully graciously hold no objection to.
This case is called, the defendant is before the court. This matter is hereby adjourned to the 29th day of April 2026. The defendant is to further enjoy the bail granted him to the next adjourned date.
Accordingly, my lord.
Yes, call the next case.
Hold the next case.
Charge number FSC/EM/EM/1 the Federal Republic of Nigeria, Abdullahi Ali. My lord, the defendant is absent.
My apologies,
Can you call the name of the person?
You call it again so that
Okay. Tax number FSC/DM/CR/14/2025 between Federal Republic of Nigeria
Abdullahi Adamu.
Defendant is absent, madam.
Thank you. Representation.
Complainant.
MB Ngohi, humbly announcing my appearance for the defendant, my lord. My lord, the matter is coming up today for continuation of hearing. Sorry, my lord, for commencement of hearing.
Continuation of
the defendant, my lord. And my lord, first of all, let me apologize for the absence of the defendant, because the fault is from me, my lord. And my lord, so the cost list a day before yesterday, when I called the defendant, he traveled with cows to Lagos. He cannot be able to come back within time to attend the court sitting. The reason is that, my lord, I have a case for myself before a magistrate court. That is why the date has escaped from my memory, because the case it affected me personally. That is why, my lord, I forget the date to inform the defendant. In view of this, my lord, I'm very sorry for not informing the defendant about the date. I humbly apply for another date, my lord, so to enable the defendant to attend his trial, my lord. I'm very sorry for any inconveniences that this might cause. I also apologize to the prosecution counsel. Thank you, my lord.
My lord, we hold no objection to the application for adjournment. Thank you.
Can you registry give us a date?
Okay. 30th April, my lord. April 30th.
This matter is hereby adjourned to the 30th of April 2026. The defendant is to continue to enjoy the bail granted him till the next adjourned date.
Ascot, please.
Thank you, my lord. I'm very much grateful.
Okay. Yes.
Tax number FSC/DM/CR/20/2022 between Federal Republic of Nigeria and Damaturu.
Defendant is not the one.
Registry, I didn't hear what you stated.
Okay.
Yes, ma'am.
Adamu Audu.
Yes, sir.
Defendant is present. Yes, my lord. Defendant is in court. He may speak outside.
Representation.
Respectfully, my lord, Usman Bamala, my humble appearance is for the complainant.
May it please your lordship, I remain Z.I. Mustafa, Mrs. Humbly announcing my appearance for the defendant, my lord. My lord, the matter is slated for judgment and subject to overriding convenience. We are ready, my lord. We apologize for the late coming of the defendant.
Registry. How many judgments do you have on Thursday? Do you have any judgment on Thursday? I can't hear you.
Yes, I'm trying to check, my lord.
12. Today is 10.
You know, you have only one.
There's one judgment. Ruling.
As the court please.
This is slated for judgment is called the defendant is before the court. The judgment is not 100% ready. It will be delivered on the 12th day of April 2026. Proceedings to be via virtual mode. The defendant is to continue to enjoy the bail granted him to the next adjourned date.
As court please. Yau ne ya kamata za a yanke maka hukunci, amma ba a shirya ba sai kai jibi shine ba ka ji a yanke maka hukunci ranar Alhamis.
Apologize to counsel on the defendant.
As the court pleases, my lord, to agree.
Also. Yes.
Charge number FSC/DM/CR/4/2021 between Federal Republic of Nigeria and Idris Yusuf, Sani Idris, Abbas Abdurrahman, Muhammad Adamu.
Yes, my lord. The first defendant is present, my lord, here at correction center and speaks Hausa language.
Yes, my lord. The third defendant is in court, my lord. Well, the fourth and fifth defendant are absent.
Representation. Counsel, you are muted. Can you hear counsel?
No, my lord, we cannot hear him.
It's still your audio. Okay.
It is affair, maybe it is not.
Still trying to.
Yes, my lord, can the court hear me, my lord?
Yes, you are audible now.
Respectfully, my lord, Usman Bamada, my appearance is for the complainant.
May my lord be pleased? I remain that I, Mustafa Mrs. Holding brief counsel for Bisha Aibu, humbly announcing my appearance for the defendants. My lord, sorry, am I audible?
Yes, you are.
Okay. My lord, there is I'm having a kind of confusion concerning the numbering of the defendants, because there are initially there were 5 defendants in this matter. So the second defendant has been discharged and acquitted, my lord.
Just a minute. Just give me one. It said initially 5 defendants.
Stop, please, my lord. And the second defendant has been discharged and acquitted by this honorable court.
Yes.
So, my lord, my confusion is Do we maintain the initial numbering, or do we move the last 3 defendants forward so that we have 4 defendants? The registry of courts keep mentioning the 5 defendants, and my own, I keep skipping the second defendant, my lord. That is the clarification I need.
As rightly stated by you, there are 5 defendants. The second defendant was discharged and acquitted. So presently, what I have before my record is the first, third, fourth, and fifth defendant.
As the court pleases, I'm grateful, my lord. My lord, the third defendant is before the court, while the fourth and fifth defendant are not in court, my lord, who are on bail, my lord.
The first defendant is before the court.
The third defendant is before the court. The fourth and the fifth defendant, who are also on bail, are not before the court.
Yes.
My lord, may we hear from the third defendant why the fourth defendant is not before the court, as I expected them to come together, my lord? And for the fifth defendant, his mother is before the court to tell us why he is not in court. My lord, may we hear from the third defendant first?
Register of court. Can you confirm whether this proceedings
As the court pleases. Sani Idris.
No, register of court. Can you confirm whether the proceedings is being recorded?
My lord, we didn't get you. The network is somehow.
Can you confirm from Hajia Halima whether proceedings is being recorded?
Okay, my lord.
Oh, are they having challenges as well?
Yes, they are recording, my lord.
Okay. So the application of counsel was
Mustafa. Yes, my lord. To hear from the third defendant why the fourth defendant is not before the court, my lord, as they are always coming together, and I expected them to be in court together.
Yes.
Sani Idris. Lawyer may kare ka take tana so ka sani. Inani Abbas Abdurrauf da Muhammad da yake tare kuke zuwa.
Abdurrauf jiya za mu tafi. Sai ya ce wai a gaya mana cikin sanya ciwo. Zuwa sai na kira kawuna.
Can you interpret what he's saying?
Yes, my lord. What he's saying is that they were supposed to come together with the fourth defendant, but he later complained of stomach pain. That is why he could not make it today, man.
Yes.
Sai na kira kauna na gaya mai cewa gashi abin da Abbas Abdurra'uf ya ce. Sai ce mana yiwuwar gabani da mamar Muhammad Adamu akan cewa shi zai taho da Abbas ne.
He called his uncle to inform him about the situation. Then the uncle asked them to come to court with the mother of the 5th defendant. That they will come at the back. They will follow them at the back.
Well, was that what he said was the uncle comes with one other defendant?
Yeah.
Was that what he said?
Yes. Now the 3rd defendant is together with the mother of the 5th defendant. The mother of the 5th defendant is right here in the court.
I wanted to record what the 4th defendant, what the 3rd defendant just said.
Kace kawunka ya ce ku tafi da maman shi Muhammad Adamu. Za ku taho tare da
gidansu ya taho da shi.
That he will go to their house and bring him to court.
Yes.
He said that is all.
My lord, regarding the absence of the 5th, may we hear from his mother, my lord, is right in the court. Oh.
Yes. Yes, my lord. This is the mother of the 5th defendant.
Yes.
Muhammad Adam.
Yes.
Ina Muhammad Adam.
What is her name?
Sunanki.
Sunan Adam, Haja Adam.
Her name is Hajia Adama.
Yes.
Ina she Muhammad Adam.
Muhammad.
That Muhammad is at home. Me yasa ba zo kotu?
Na?
Me yasa bai zo kotu yau ba?
Kawai matsalar nan da yake tare da shi ne na farko wanda na gaya muku. Dan ni kaɗai ba zan iya kawo shi ba. A yanzu ma da muka ba shi maganin bacci.
Yes, my lord. She said he's at home due to the last explanation she made in the court, my lord. Last time. That she alone cannot come along with the defendant to court because of his condition. Yes. Due to his condition, my lord.
Counsel, are you still there?
Yes, my lord. My lord, we apologize for this inconvenience, my lord, and we urge this honorable court to proceed with the sentencing, my lord, of the 1st defendant, And on the other hand, my lord, so at the end, my lord, adjourn the matter, my lord, to a later date for the continuation of, for the opening of the defense of the third, fourth, and fifth defendant, my lord. Before the adjourned date, my lord, we will do the needful, my lord, and put our house in order to come ready for the defense.
As copy, my lord.
Yes, counsel, give me 1 minute.
As copy.
Yes, counsel, go ahead.
My lord, we hold no objection to the application of the counsel to the defendant as it is the right application for the court to make a progress on behalf of the first defendant and reserve the hearing, the continuation of the hearing till on that date. Thank you very much. And we urge the counsel to the defendant to make sure that the defendants appear before this honorable court in the next adjourned date. Thank you very much.
My concern about this case, about the defendants in these cases, this case has been dragging on for long. If one defendant shows up, another would not come up. So, and the mother of the fifth defendant just informed the court, like she did last time, that the fifth defendant is almost unfit to stand for trial. None of you counsel said anything regarding that.
Yes,
so
my
we
lord.
keep on adjourning.
My lord,
yes.
we will do the needful, my lord, before the next adjourned date, my lord, regarding this case.
Yes, my lord, I actually remember vividly of what you have just said, my lord, but my lord, the counsel to the defendant, my lord, stand in better position to speak for their clients, my lord. As far as I am concerned, my lord, my own is to make sure that the matter has been concluded with logical conclusion in the prosecution. And there is on behalf of the defendant, my lord, I think the defendant stand in the better position, my lord, on behalf of their.
My lord,
listen, Daddy.
Yes, my lord.
Tell the elderly lady to go and sit.
Mama, she just presented.
Yes, counsel, you are about to say something.
I was under the impression that this time around the fifth defendant will be in court, only to find out that it is his mother still that came to make the same complaint, my lord. Because I was unable to communicate with her, it was the substantive counsel that communicated with them, and he said all of them will be coming. So that is why I did not come with any explanation, or I did not prepare anything to that effect, my lord. But hopefully, my lord, before the next adjourned date, we'll put our house in order and do the needful. We'll address that, my lord.
Sentence.
As the court pleases.
The defendants in this case are Idris Yusuf, Sani Idris, Abbas Abdurrauf, and Mohammed Adamu, who are standing trial before this court in a two-count charge number FFCD MCR 4/2021, dated 25th June 2021 and filed on the 28th June 2021 by the National Drug Law Enforcement Agency against the defendant. The charge reads that you, Idris Yusuf, male adult of 9 ward, and you, Abbas Abdurrauf, male adult of same 9 ward, and you, Mohammed Adamu of Platari, Sabon Garin Kanuri ward, and one Abba Idris of same 9 ward, who is now at large, all of Nguru town, on or about 18th day of June 2021 at Musa Abdullahi's house, 9 ward, Guru local government area within the jurisdiction of this honorable court, without lawful authority, found and arrested in possession of 60.4 kilograms of suspected cannabis sativa, a substance similar to cocaine, heroin, and LSD, and also conspired amongst yourselves and possessed 1 kilogram of suspected psychotropic substance similar to cocaine, heroin, and LSD, thereby committed an offense contrary to and punishable under Section 14 sub B of the NDLEA Act, N30 Laws of the Federation of Nigeria, 2004. All the defendants pleaded not guilty to the charge when they were arraigned on 8th July 2021 and trial commenced. There was a lot of hiccups that stalled the trial at different points. There was a plea bargain agreement that failed. There was also a trial within trial. At the end of the prosecution's case, the defense counsel entered a no-case submission, to which the court, after a considered ruling, acquitted and discharged the second defendant and ordered the first, third, fourth, and fifth defendants to enter their defense. At the last adjourned date, being the 17th day of February 2026, the first defendant, Idris Yusuf, changed his plea from not guilty to guilty of the indictment in the two-count charge dated 25th June 2021 and filed 28th June 2021 pending before this court. He was subsequently convicted. The sentencing was deferred till today to enable me to have a deeper reflection on the appropriate sentence which will meet the justice of this case. In criminal jurisprudence, the two broad goals of judicial sentencing are, firstly, to seek the reform of the convict so that by the time he completes the penal custodial sentence, which the court imposes, he will return to the society as a better and more responsible citizen who has respect for the laws of the land. The second goal is to impose such sentence as will serve as deterrence to the other persons who are yet to be caught by the proverbial long arm of the law, who are also involved in similar acts for which the convict is being punished. Whilst the first goal focuses on the convict in the dock, the second goal, in my view, focuses on both the convict in the dock and the society at large, especially for persons who are or may be involved in similar criminal activity for which the convict is being sentenced. In relation to the convict, the sentence the court will impose is to be such as will deter him from going back into the same or similar activity as constituting the offense for which he is being punished. Whilst for the other persons out there who are yet to be caught in the web of the law, to persuade them to desist on pain of similar punishment from continuing with or not to go into similar activity. These goals are no doubt largely sociological in nature. in striving to attain both goals, which are really not mutually exclusive. It is the desire of every court to strike a balance in order to ensure that the attainment of one goal does not ultimately and invariably lead to the defeat or frustration of the other. In its efforts to achieve this, the court takes into consideration a number of factors, and the court is, in being able to do this, is required as a baseline to be able to locate the station in life of the convict. By this, the court takes into consideration the attitude of the convict upon his arraignment on the indictment, where a defendant who truly believes and accepts that he was guilty of the allegation in the indictment and readily pleaded guilty upon his arraignment in court, it is part of the factors which the court is required to take into consideration when imposing a sentence. Quite often, except where there are overriding considerations or extenuating issues, such a convict will be given a discount in terms of his or her sentence. The court is also required, especially in cases involving illicit dealing in narcotics, to take into consideration the nature of the drugs involved. In this case, it was both cannabis sativa and psychotropic substances that the defendant was convicted of being in unlawful possession with and conspiracy. The provisions of the NDLEA Act Supra stipulates different regime of punishment. For unlawful possession of cannabis sativa, in contrast with other hard drugs and psychotropic substances, such as cocaine or heroin, the court in such cases will consider the quantity found in possession of the defendant when arrested. This enables the court to ascertain whether the defendant is a mere user or abuser of hard drugs or is someone who is either a retail or commercial dealer. By considering the quantity of the hard drugs, it enables the court to assess the extent of harm which the defendant/convict has done to himself as a consumer or to the society as a retail or commercial dealer of illicit hard drugs. Again, the location of the arrest of the defendant is an important consideration because the court will frown at a defendant who attempts to transport hard drugs. Okay, I can see the defendant there. Cannabis, example, cannabis sativa, cocaine or heroin or controlled drugs from state to state, as much as one who is selling it in a marketplace or renting a shop and clandestinely in the guise of selling provisions, selling illicit substances. In view of the fact that in either of these two scenarios, the society is at the receiving end, therefore, the court will not likely be lenient with such defendants. The court, in relation to a defendant who attempts to transport either hard drugs or controlled drugs, will also be concerned with the mode of concealment. This enables the court to assess the defendant as either an incorrigible dealer or trafficker or a novice who has only been introduced into the illicit business. The factors which the court will consider are almost inexhaustive, all being in an effort to locate the station of life of the convict in order to impose such punishment as will meet the justice of his case. This is the reason why, in my view, judicial sentencing is perhaps the most important aspect of criminal justice and adjudication process, because it is in this regard that the law comes out real to the defendant and to the larger society. A casual attitude by the court to these issues will invariably lead the court to impose a sentence punishment that may be too harsh as to defeat the attainment of the goal to seek the reform of the convict, and which may invariably impair the attainment of even the goal to seek for deterrence in both the convicts and the larger society. Where the sentence is comparatively too harsh and out of tune with the realities of the convict station in life, such excessive punishment may eventually well up in the convict a spirit and attitude of indignation, and he will see both the state and its law as rather so unjust. Such a harsh punishment may never appeal to the spirit of remorse or of contrition, as such a convict will bear an unforgivable grudge against both the state, its laws, and its people, and will seek to revenge even after he may have served out the harsh punishment unjustly imposed. On the contrary, where the sentence is too light, the convict takes it as a slap on the wrist, and such comical sentence will never encourage the convicts to turn over to a new leaf and be reformed. In view of the fact that possessing, dealing, or trafficking in illicit drugs has been adjudged as a transnational organized economic crime, such a convict, once he has finished his sentence, will readily go back to the same illicit business in the hope that even if he's caught, it's a question of a few months incarceration and he'll be released to return to the business and make good money in illicit trafficking in hard drugs. A sentence that is comparatively too light will also not serve as a deterrent to the individuals who are involved in similar criminal activities or deter those who are already contemplating getting involved or being groomed by the drug lords to be used as traffickers for a commission of fees. It is obvious that when this occurs, the court has not discharged its statutory duty well in ensuring that its sentence is one which strikes the delicate balance, which I've briefly analyzed, and which are essentially sociological in nature. In my efforts to do this, I took the opportunity to defer the sentence to today to read the extrajudicial statement made by the convict, which was in the court file portion to Section 122 Evidence Act, as well as other documents in the file, including a previous warrant of conviction. When I read the case file, and the statements volunteered by the convict, I'm left with the impression that in this illicit trade, he is not a novice. And this impression is confirmed by the previous record of his involvement in this type of crime prior to when he was arrested in June 2021. One Bagudu David, the litigation officer, as well as the exhibit officer of the NDLEA Yobe State Command, opposed a bail application of the first defendant, now convicts, by deposing that the convict standing trial alongside three others on 2 counts charge of conspiracy to possess 60.4 kilograms of cannabis sativa and conspiracy to possess 1 kilogram of psychotropic substance, both contrary to and punishable under Section 14 of the NDLEA Act, is an ex-convict and was sentenced to 7 years imprisonment with an option of fine of 250,000 on the 2nd May 2017 before the Maiduguri division of this court. And a certified true copy of the warrant of the said conviction was annexed as Exhibit NDLEA 1. This attachment means that Idris Yusuf, as an ex-convict, has committed a similar offense to which he has been earlier convicted. And to worsen matters and to signify that the convict is an unremorseful person, when arrested on this instant allegation of conspiracy to possess 60.4 kilograms of cannabis sativa and 1 kilogram of psychotropic substance, he was granted administrative bail, but subsequently arrested on another different allegation of a 2-count charge, which means that he is an unrepentant convict. By the provision of the law, let me skip that. The defendant has exonerated the second, third, and fourth defendants from liability. Second, third, fourth, and fifth defendant from liability, contending that the stuff belongs to me. I'm the owner of the items, and I plead guilty. My explanation is that these things belongs to me and not to the other defendants. The prosecuting counsel, in his response, contended that the question one would tend to ask is, why the change of plea at the end of trial? And secondly, a careful perusal of the charge shows that the defendants were charged with conspiracy. Each of the individuals have played roles in the case, while the first defendant is the principal offender with the others, and so that does not exonerate the evidence the prosecution has produced before this court, that the admission of the first defendant exonerating the charge against the other defendants from meaning taking the bullet by the first defendant on behalf of the 3 defendants will not stop the 3 defendants from dying, and applied to the court to convict the first defendant for pleading guilty. The defense counsel contended that the remaining 3rd, 4th, and 5th defendants are victims of circumstances. The prosecuting counsel, during allocations, listed some of the aggravating factors that from the available information at his disposal, the convict has been on the wanted list of the NDLEA for over a decade, that there are about 2 other charges before the court, all bordering on drug-related matters, that the convict has made the court to undergo a rigorous trial before he eventually changed his plea at the end of the trial. More so, for all these 5 years of trial, the convict did not say a word but suffered the other 4 defendants who were attending trial regularly, only for him to come to court to change his plea at the dying minute, that the NDLEA is investigating the wealth of the convicts based on money laundering case, and some of the wealth of the has been recovered already and will apply for future, as the wealth was earned through illegal dealings in narcotics and psychotropic substances. The convict, it seems, is a drug baron, I so hold, who, as an ex-convict, was sentenced to 7 years imprisonment with an option of fine of 250,000 naira on the 2nd May 2017 before the Maiduguri division of this court, and a certified true copy of the warrant of the said conviction was annexed as Exhibit NDLEA 1. In the final analysis, the convict is hereby sentenced on the 1st count charge of conspiracy to possess 60.4 kilograms of cannabis sativa to 5 years imprisonment. The convict, Idris Yusuf, is further sentenced on the 2nd count charge of conspiracy to possess 1 kilogram of psychotropic substance, both offenses contrary to and punishable under Section 14, to 3 years imprisonment. The sentence shall run consecutively and be deemed to have commenced from today, the 10th day of March 2026. The seized drugs, being cannabis sativa admitted as exhibits, weighing 60.4 kilograms and 1 kilogram of psychotropic substances, respectively, is hereby confiscated and shall be forfeited to the federal government of Nigeria. The said exhibit shall be destroyed by burning by the NDLEA along with other judicially condemned narcotics and psychotropic substances at a public function to be organized by the NDLEA. The said event shall be witnessed on NDLEA's invitation by representatives of the Nigerian Police Force, the Department of State Security Services, and Nigerian Security and Civil Defense Corps, as well as the print and electronic media and the general public. This shall be the court sentence of the convict, which is imposed after reflecting deeply on the appropriate sentence. The sentence is no doubt light. It was deliberately made so in order to encourage the convict to quickly retrace his steps and return to the society as a changed person. The convict may not be so lucky if in future he is caught and charged for a similar offense. This shall be the court sentence. Mr. Salisu.
Yes, my lord.
Can you interpret to the best of your ability?
Yes, my lord. Idris, yau ita ce ranar goma ga watan wannan shekara ta 2000. Kamar yadda yanzu aka gabatar wannan hukunci akan shari'a da ake tuhuma kamar haka. Wato an kawo ka gaban wannan kotu ne da wani kaya ne wanda ya kai kilogram 50.3, sannan kuma akwai
60.4
na wani ƙwayoyi masu birkitarwa. A gurguje dai zan ma kamar haka. To bisa ga la'akari da kotu ta yi, wannan kayan kotu ta tabbatar da cewa ba wai mai ko amfani da shi ba ne, ya zama mai yin kamar safara ne, sayarwa da harkokin al'amarin. Don haka hukuncinsa gaskiya yana da tsanani sosai, kamar yadda kotu ta sanar da mu yanzu cewa. Sannan kuma kotu ta yi dubi da la'akari da yanayin yadda aka samu abin da yadda kuma kotu ta gudanar a ƙarshe ma dai har akwai wasu wanda suke cikin magana wanda daga ƙarshe ka zo ka nuna ma cewa wannan mutanen ba masu laifi ba ne, duka kai ne ma kawai mai laifin kayan ka duk dai kamar yadda yanzu kotu ta sanar. Sannan kuma kotu ta ce a sanar da kai cewa wannan laifuka guda biyu, shi wannan guda ɗayan na farko kotu ta ɗaure ka shekara 5, shi ma ɗaya na biyun kotu ta ɗaure ka shekara 3, amma dukansu kowanne zai yi daban-daban ne.
Thank you. Call the next case.
Only this case.
Charge number FSC/BM/CR/6/2021 between the Federal Republic of Nigeria and Idris Yusuf.
Idris Yusuf. Yes, my lord, the defendant is present. Speak also, my lord.
Is that CR6?
Yes. Sorry, my lord. For the continuation of hearing of the third, fourth, and fifth defendant, no data has been given.
Okay, I'm sorry. Yes, give us a date.
Yes, 30th April, my lord. April 30th.
Okay, thank you. Meanwhile, this case has been adjourned to the 30th day of April 2026 for the continuation of defense of the third, fourth, and fifth defendants. They are to continue to enjoy the bail granted them till the next adjourned date.
As the court pleases, my lord, we are grateful.
Okay. Yes. Registry of Court.
Charge number LPS/BM/CR/6 2021 between the Federal Republic of Nigeria and Idris Yusuf.
Yes, my lord, the defendant is present, my lord, and speaks Hausa.
Yes.
Sorry, my lord, the prosecution who is supposed to announce his appearance first is muted. I don't know, is it due to network or is that?
Representation. Counsel, we can't hear you. Your audio is still not audible enough. The prosecuting counsel is still not online.
Okay. Respectfully, my lord Usman Bamala, my appearance is for the complainant.
May it please, my lord? I remain that I Mustafa Mrs. Holding the brief of Bishop Aibu, humbly announcing my appearance for the defendant. My lord, the matter is slated for sentencing, and subject to your overriding convenience, we are ready.
We are equally ready, my lord.
This matter, Federal Republic of Nigeria versus Idris Yusuf, CR6 2022, as well as the sister case of Federal Republic of Nigeria, Idris Yusuf, CR16 2024, are both for sentencing. The sentence will be delivered on the 12th day of March 2026. That's 2 days from today. Therefore, the matter is adjourned to the 12th day of March 2026 for sentencing.
As God please. Idris, kamar yadda kotu yanzu sanar, akwai tuhuma guda, akwai shari'a guda biyu da zaka da a gabatar. To amma yanzu guda biyun duka wanda da yau za a gabatar da su kuma da yiwu ba, amma za a yi shi zuwa ranar 12 ga wata, ranar Alhamis kenan. In Allah ya kai. Thank you, that's all, my lord.
Okay, for you at the correctional center.
Thank you.
Okay, thank you, Mr. Salisu.
Thank you very much.
I thank the staff of correctional center as well. Thank you so much.
Thank you, my lord.
Okay, you're welcome.
Thank you.
Thank you. Okay, you're welcome. Registry of court.
Yes, my lord. That is all for the day, my lord.
Okay, but we have cases for tomorrow.
My lord, I think there is one CR 16. Were they joined together, my lord, to be adjourned to 12th day of March 2023?
Yes.
Okay.
Yes.
So, thank you, madam.
I said both their sister cases, the sentencing will be, the matter is adjourned for sentencing. Registry of court.
Yes, my
The
lord.
case is for tomorrow, that is Wednesday.
Yes, my lord.
The defendants, are they all on bail?
Let me check, my lord. Yes, my lord. They are on bail, my lord. They are all on bail.
All of the defendants are okay.
No, there is one who is at the correctional center, my lord. Garba Elijah
Okay,
Alasan.
which case is that?
Garba Elijah Alasan.
Okay, then you have to intimate correctional center to join in tomorrow. Maybe we start with that case. If
Okay, my lord.
we have only one defendant at the correctional center. How about the cases for Thursday? Are they all on bail?
Yes, they are all on bail.
Okay.
Yes.
Okay, thank you.
Thank you very much, madam.
Okay, I appreciate staff of the Federal High Court as well as Fortune Technologies for assisting us to do this virtual proceedings, as well as all counsel that appeared today. It's like having the challenges have subsided to a large extent.
Yes,
it
ma'am.
seems that is it the Damaturu axis, the Yobe axis that's having these challenges?
Including Maiduguri,
Oh,
my
you're
lord.
not sorry?
Including Maiduguri.
Oh, I see. Okay. Okay, thank you anyway for your assistance.
With the rate of the increase, my lord, and the challenges of the insecurity, my lord, has made that of the northeastern states, my lord, worse in as far as so many things, both the economy and as well as the other activities worst. Even though now it is a global issue, my lord, because the issue of the ongoing war around the world, my lord, is affecting both the economy as well as the network. Why I said network, my lord, is that countries like Nigeria, who ordinarily, my lord, we doesn't have a stable network. So, my lord, plus what is actually happening in the world, my lord, is now becoming worrisome, and it's even I don't know how to describe it. Because, my lord, it has forced a lot of companies, my lord, to enter into force majeure to and that is affecting the economy of the world at large. So you just need to pray.
Because we have no choice but to continue with the virtual proceedings, because if we stop it, bringing inmates from correctional center is going to be more difficult. It has always been difficult, but to bring out inmates from the correctional center to court 200 kilometers to and fro is not feasible. So we have no choice but to struggle like that. But at least towards the end of the most of the proceedings, we have been able to a large extent to understand each other. So I thank all counsel that appeared, as well as the Registry of Court, as well as Fortune Technologies for their assistance. Okay, see you tomorrow. Thank you so much.
Thank you, madam.
Have a nice day.
Okay, I wish you same.